But for starters, why don't you just sell the house and split the equity? That'll give you guys both peace of mind on the debt, assuming there's equity in the house. Just sell it and split it. There's usually equity in the house. I've seldom came into contact with community residences that were void of equity unless somebody took out like an equity loan on the house or something like that. To the extent that you haven't done that, then sell the house, take the equity, and pay off your community debts, which would include the stupid wedding loan. I bet you're regretting that one now. I bet you they looked really cute for their wedding too. Cabbages all over the place. Cauliflowers on the ceilings and on the centerpieces. I bet you they had like a really nice tux, and she had like the bridesmaid's dress from that movie, the one from France that was personally stitched by that guy or whatever.
Okay. Oh my God.
And now they're getting a divorce 2 years later. Here's my take on these people.
I do agree with you. Wedding loans are stupid. They're plain on stupid. That's it. They're stupid.
Well, they don't have much marital equity to speak of. They've only got married 2 years ago. I'm just going to go out on a limb and say that this lady's probably in her 20s. Doesn't have any business getting married to anybody. She's treating this as if it's a
toddler means
roommate.
Two?
I think you might like this one. Okay, so my husband and I are still together.
Me?
What?
You said I may like this one?
You know, your voice is so abrasive. Like I was like literally sitting here and like your voice, you said, me?
Where's my mouse when I need it?
It sounded like an alarm clock. What was that?
Oh, no.
It's all right, Melissa.
Of it. Uh-huh.
Okay. The typical way that these kind of hearings work is because domestic violence and harassment is such a safety issue, it's a concern for the court, they will usually err on the side of caution, which is why there was this hearing on the 6th, even without Etchard present, without any evidence being presented. Just tell me what is going on. And basically, if what they're saying would be true, amounts to harassment, then they'll just grant it. And we'll figure it out in a few weeks at an evidentiary hearing, which is pretty much what happened here. So there was another hearing on the 23rd of October that was not ex parte. Etchard was there representing himself. Jane Doe was there with a new attorney, and they had about an hour and a half hearing with a judge. That was the one that I had mentioned earlier. That was he just looked really older. I don't know. Some of these judges, they take on these DV cases and they're like in the midst of retirement. It might have been one of those, which are my favorite kind of judges because they have so many different stories to tell in chambers. But at that hearing, now the way they do it, Eliana, it's crazy because they're very strict about time limits. They basically gave, you got 20 minutes to present your side. I'll give him 20 minutes. If you guys are efficient with what's going on, I might allow you more time. And they're really hard to say, hey, you got 1 minute, counselor. Hey, could I ask one more thing? No. Oh, okay, moving on. There was a lot made in that hearing that, hey, Mr. Etchard has had like 30 minutes to speak to R20. Can I say something else? No, you can't because you were not particularly efficient. And it's not really all that relevant, counselor. What I did notice is that in that hearing, the judge seemingly was trying to give Mr. Etchard every opportunity to make a record of his case. In my experience, when a judge tells you that, I'm going to give you every opportunity to give out all of your evidence, it's usually because they plan to rule against you. There was an objection made at that hearing, which rubbed me the wrong way, that I felt it's the danger when you're a pro per. Because Mr. Etchard probably has adrenaline pumping through his veins. He's probably not done this many times. He probably has a very limited knowledge of the rules of evidence. But one of the things that he was trying to introduce was there was a picture of a sonogram or an ultrasound. It was the one that's basically been the question, the subject of this litigation going forward, that he says, Your Honor, I got this crazy evidence. I got this side-by-side image. Here's the one that was sent to me, and here's one that I found randomly off of YouTube. And if you
Google.
Well, he said YouTube. He said it was YouTube. It was a video from 6 years ago that's an ultrasound that has all the same markings, all the same movements. If you superimpose, I think what he's trying to say was, which he didn't say, but if you superimpose it, it's literally the same video.
Same one.
And he makes that claim, and the judge is like, well, Etchard, why don't you tell me how I'm supposed to believe or know? How could I trust you when you say that that's not just something that you got from some other person purporting to be the very same thing? And there was a big deal about, well, this has been published before or sent to other people, and it might have been one of his followers that sent him something. In other words, not authentic.
Yes.
When he introduced it the first time, I was thinking, hey, objection, lacks foundation. Where's this video from? I haven't had an opportunity to review it. Her attorney did not object to it at first. He did object to it 15 minutes later. He was like, yeah, you should have said that like 15 minutes ago, because that was essentially, it was an authentication issue.
Yes.
But the judge is like, I think that you're trying to get me to believe that this is something that she's done before, and because she's done it before, she's doing it to you now. And what he should have said was like, no, Your Honor, what I'm saying is she's purporting that this ultrasound was created around the time that she got pregnant, which would at the time would have been around May. So what, 5 months prior? But this video was found 6 years ago. And if the origin is 6 years ago and it's the same video, then it's not an authentic video of a real ultrasound, which would have been the correct objection there or argument to make. And it was highly relevant because she's claiming defamation and harassment on the basis of this. And it was the subject of the order that came out a couple days ago. So basically, if he can prove that it was a fraudulent ultrasound, then it throws defamation out the window. And the harassment and stuff and all those things. And his attorneys are arguing that the only reason that the order of protection was granted was because of this ultrasound video, But if it was found to be inauthentic, then we would be having a different conversation. And then, of course, Jane Doe's attorneys are arguing, yeah, but that wasn't the only basis for him granting. It was the harassing text messages and all those things. So domestic violence is a very broad spectrum of activities. And you heard in those hearings them use the term disturbing of the peace.
Yes.
Which at its most base level is what domestic violence is. It's not necessarily physical violence. It could be anything that disturbs the peace of any individual, which Mr. Etchard could have similarly filed an order of protection against harassment from this lady that is claiming that I'm pregnant with twins, but she's not allowing me to see the ultrasound to authenticate it. And, and I'm going to play those arguments because there's very important differences in those arguments. But it is Hardy saying that, look, I don't believe that this lady's pregnant. I haven't, to my satisfaction, verified the pregnancy is real. And so, he could have filed his own order of protection based off of that, but he didn't. And so this was her order of protection. So this is how he violated the restraining order. I saw somebody in the chat before I get started with that say this is not about credibility. No, it's not specifically just about credibility to the extent that we don't have provable, verifiable evidence otherwise. Because really where the court is going with this is, hey, Jane Doe, you're going to have to show me something that shows that you were verifiably pregnant. I know you got these HCG tests. You're going to have an expert come in. It needs to be verifiable scientifically. Otherwise, I'm going to have questions. Because with a lack of evidence, all I meant by that was this. If there is an evidentiary tie, meaning the weight of evidence is a literal tie, the tiebreaker is credibility, which means something. And so, yes, the evidence will speak to itself, but credibility is enormously persuasive in cases like this.
Just to give you an example, I did have a case where at the end, the judge said, I don't believe either one of the people. I don't know where to stand. Yeah. But just because I have proof that this one at some point did something that it was not credible, I'm going to go ahead and then give it to the other person.
Exactly.
That's the tiebreaker.
And it really sucks when there's evidence that you manipulated evidence that is floating around in the record that is not disputed. That sucks. That's like the worst. It's almost like in boxing, if you were to get knocked down, you get a standing 8 count, you get a point withdrawn, I don't know if that's going to land or not. But at any rate,